We are continuing our conversation on the United States and LGBTQIA plus history and laws. This is part 4, and today we're going to talk about the military. So the Articles of War of the United States of 1916 included Article 93. Stating that any person subject to military law who committed assault with intent to commit sodomy shall be punished as a court-martial may direct. It was modified in 1920 to make sodomy a crime. It was the first express prohibition of homosexuality or homosexual conduct in the armed forces in the United States. Before 1949, the year my parents were born, each branch of the military would charge those caught engaging in homosexual conduct with sodomy, court-martial them, and issue them a dishonorable discharge. In 1940, psychiatrists Harry Stack Sullivan and Winifred Overholser formulated guidelines for psychiatric screening for military inductees. Both believed that homosexuals should not be inducted. In 1941, the United States Army Surgeon General's office issued a circular classifying homosexual proclivities as disqualifying inductees from military service. The United States Navy and the Selective Service adopted similar exclusionary policies. The Women's Army Corps adopted a similar policy in 1944. Due to mass mobilization and deployment of troops for operations in World War II, it became impractical to convene court-martial boards for homosexual conduct offenses. Commanders instead issued blue discharges, a form of administrative military discharge, to homosexual personnel. The Veterans Administration denied blue discharge veterans the benefits of the GI Bill as a general policy. In 1944, a policy directive ordered that homosexuals were to be committed to military hospitals, examined by psychiatrists, and discharged. In October 1949, the newly consolidated Department of Defense standardized anti-homosexual regulations across all branches of the military. Homosexual personnel, irrespective of sex, should not be permitted to serve in any branch of the armed forces in any capacity, and prompt separation of known homosexuals from the armed forces is mandatory. President Harry S. Truman signed legislation on May 6, 1950, creating the Uniform Code of Military Justice. Its Article 125 forbids sodomy among all military personnel, defining an offender as any person subject to this chapter who engages in unnatural carnal copulation with another person of the same sex or opposite sex or with an animal is guilty of sodomy. Penetration, however slight, is sufficient to complete the offense. In 1981, the Department of Defense issued a new regulation on homosexuality that was designed to ensure withstanding a court challenge by developing uniform and clearly defined regulations and justifications that made homosexual status, whether self-applied or by the military, and conduct grounds for discharge. Homosexuality is incompatible with military service. The presence in the military environment of persons who engage in homosexual conduct or who, by their statements, demonstrate a propensity to engage in homosexual conduct, seriously impairs the accomplishment of the military mission. Does that sound familiar to anybody at all? Because I'm almost positive that these words were used to describe our transgender siblings in an executive order signed by Donald Trump just recently. Anyway, anyone found engaging in homosexual activity and or identifying as gay would be separated with an honorable discharge. The DoD policy has since withstood most court challenges, although the United States Supreme Court has refused to weigh in on the constitutionality of the policy. How many of you remember this? 1994. Don't Ask, Don't Tell was implemented. Don't Ask, Don't Tell prohibited military personnel from discriminating against or harassing closeted homosexual or bisexual service members or applicants, while barring openly gay, lesbian, or bisexual persons from military service. The policy prohibited people who demonstrate a propensity or intent to engage in homosexual acts from serving in the armed forces of the United States because their presence would create an unacceptable risk to the high standards of morale, good order and discipline, and unit cohesion that are the essence of military capability. Okay. The act prohibited any LGBTQIA plus person from disclosing their sexual orientation or from speaking about any same-sex relationships, including marriages or other familial attributes, while serving in the United States Armed Forces. Military or appointed officials do not ask about or require members to reveal their sexual orientation. The act specified that service members who disclose that they are homosexual or engage in homosexual conduct should be discharged. After the policy was introduced in 1993, the military discharge was over, 13,000 troops from the military under Don't Ask, Don't Tell. Discharges exceeded 600 every year until 2009. In 1998's Andrew Holmes versus California National Guard, the Ninth Circuit Court of Appeals upheld Don't Ask, Don't Tell. The court decided that a member of the National Guard could not be discharged for saying publicly that he or she is homosexual or bisexual, but could be restricted to assignments that did not require recognition by the federal government. In March 2005, Representative Martin T. Meehan introduced the Military Readiness Enhancement Act in the House. It aimed to amend Title 10 of the United States Code to enhance the readiness of the armed forces by replacing the current policy concerning homosexuality in the armed forces, Don't Ask, Don't Tell, with a policy of non-discrimination on the basis of sexual orientation. He would introduce the bill again in 2007 and 2009. On September 9, 2010, Judge Virginia A. Phillips ruled in Log Cabin Republicans versus United States of America that the ban on service by openly gay service members was an unconstitutional violation of the First and Fifth Amendments, because it was. And let's not forget the Equal Protection Clause of the 14th Amendment. On October 12, 2010, she granted an immediate worldwide injunction prohibiting the Department of Defense from enforcing Don't Ask, Don't Tell, and ordered the military to suspend and discontinue any investigation or discharge, separation, or other proceedings based on it. The Ninth Circuit of Appeals issued a stay of the injunction. After reviewing the constitutionality of Don't Ask, Don't Tell, on October 19, 2010, military recruiters were told they could accept openly gay applicants. The Don't Ask, Don't Tell Repeal Act of 2010 was enacted in 2010, and it repealed Don't Ask, Don't Tell, allowing gay, lesbian, and bisexual people to serve openly in the United States Armed Forces. The act did not ban discrimination on the basis of sexual orientation in the military. That was provided for in the proposed Military Readiness Enhancement Act. Okay? Now, since Don't Ask, Don't Tell ended in 2011, persons who are openly homosexual or bisexual have been able to serve. The Marine Corps, of all branches, was the first branch of the armed services to recruit from the LGBTQIA+ community. On September 30th, 2011, under Secretary of Defense Clifford Stanley, they announced the DoD's policy that military chaplains are allowed to perform same-sex marriages on or off a military installation where local laws permit them. Okay. December 2011, the Senate approved 97-3 an amendment removing the prohibition on autonomy found in Article 125 of the Uniform Code of Military Justice. The House approved an amendment banning same-sex marriages from being performed at military bases or by military employees, including chaplains and other employees of the military, when acting in an official capacity. Neither amendment appeared in the final legislation. It is estimated that approximately 100,000 individuals were discharged between the beginning of World War II and the repeal of Don't Ask, Don't Tell in September of 2011. July 2012, the Department of Defense granted permission for military personnel to wear their uniforms while participating in the San Diego Pride Parade. This was the first time that U.S. military personnel were permitted to wear their service uniforms in such a parade. August 14th, 2013, the Department of Defense, DoD, announced that it would provide spousal and family benefits to service members in same-sex marriages on the same terms as it does to those in different-sex marriages. The benefits, which include health care coverage, housing allowances, military ID cards, and survivor benefits. September 13th, 2011, the VA home loan benefits were extended to include service members in same-sex marriages. They kicked it up a notch in 2014. The Department of Veterans Affairs, the VA, announced that it would only provide benefits to the same-sex spouses of veterans who were either married in the state in which they resided or lived in a state that recognizes their marriage when they apply for benefits. The National Defense Authorization Act for fiscal year 2014 repealed the ban on consensual autonomy found in Article 125 of the Uniform Code of Military Justice. 2015, Defense Secretary Ash Carter added sexual orientation to the list of non-discrimination protections under the military's Equal Opportunity Program. However, LGBTQIA+ service members and veterans continue to face discrimination in the Veterans Health Administration. Often, healthcare systems deny adequate services and visitation rights to same-sex couples. 2021, President Joe Biden announced the Veterans Administration would start providing benefits for service members who received other than honorable discharges before Don't Ask, Don't Tell was enacted and while it was in effect, because of their sexual orientation. More than 800 veterans who had been previously dishonorably discharged under Don't Ask, Don't Tell had their cases reviewed and discharge papers automatically updated to honorable discharge. With this review, nearly all of the 13,500 people who were dishonorably discharged under Don't Ask, Don't Tell now have an honorable discharge, and as a result, can access benefits for veterans. In August 2024, a federal Virginia judge immediately ordered that HIV-positive individuals with an undetectable viral load and also who are fit and healthy must be allowed, permitted, and included within the U.S. military. Official policy for many decades by the Pentagon within Washington, D.C., had HIV-positive individuals were explicitly banned from the military outright.